opportunities to work on meaningful assignments. The Accelerator program, which combines job simulations, skill-based courses, and one-on-one mentorship. The Collective Council offers law students practical exposure through job simulations that mirror real-world work and one-on-one mentorship with experienced professionals, helping them build confidence and career-ready skills.
Good evening, Sakshi. I'm sorry, who is it? Good evening. Are we ready to start?
Ma'am, just moderator will introduce you, then we'll start.
Okay, thank you, thank you. Sorry for the delay.
No issues, ma'am.
It is my privilege to introduce our distinguished speaker for today, Advocate Vedika Mittal ma'am. She is a respected professional in the field of intellectual property law. Their expertise and experience have contributed significantly to understanding and applying this area of law. On the behalf of Collective Counsel, we extend a warm welcome to you, ma'am. With that, I invite Advocate Vedika Mittal ma'am to lead us into today's session. Over to you, ma'am.
Thank you. Thank you so much for your kind words, Shalu. Firstly, I would like to apologize for the delay. There was some network issue from my end, but not delaying it further, let's actually start by. So, what are we going to do for the next hour is roughly talk about a lot of maybe a subject, whether you realize it or not, in the present, almost every aspect of modern life. Uh, it surrounds your life is actually surrounded by it. You would not, because if you're not aware of it, then maybe you won't realize it. It is it is present literally in, let's say you happen to buy a pair of shoes because it has a brand on it. It is present when you watch a film or maybe listen to a song. You use computer program, buy a pharmaceutical product, could be medicines. Look at the unique designing of a bottle, order products from particular geographical region, that, or even when a company tries to protect a secret formula or a business strategy. So this subject, this thing, if you've not realized by now, that is actually what intellectual property law is. Now, before I get into the statutes, the sections, or the cases, I would maybe begin with a very simple question. And guys, we're going to keep it very interactive. I hope all of you can, I'm going to throw a lot of questions, and there's no correct or wrong answer for any question. It What I understand of law is more of, understand it maybe as something which every someone with a common sense can answer it. So we're going to keep this session very interactive. I hope all of you are going to give me a response, and it's going to be a learning session for all of us. So maybe why doesn't someone explain me, what do you understand by the term property? Something as simple as property. Anyone?
Pardon, ma'am, come again.
If you could tell me, what do you understand by the term property? I think Dhruv wants to answer. Dhruv, please go ahead.
Some properties that in which we have an ownership of that, it can be tangible or intangible, or
Wow,
something like
that
movable or
is
immovable.
that is very nice. The fact that you understand this. So, usually, for common people, when they hear something like property, think about something that's tangible. That could be a land or a house, a car, jewelry, and perhaps something as simple as a mobile phone. But when we talk about intellectual property, it is completely different from, because think about it. what is being protected is not necessarily something you can touch. This is something which is protected maybe because of an invention. It could be a song, it could be a picture, it could be a logo of a brand, or maybe the visual appearance of a product. It may be the reputation that is associated with that brand. It may be the confidential information that company does not want to disclose to anyone. So the World Intellectual Property Organization, or WIPO, broadly describes intellectual property as, something that is the creation of your mind, including inventions, literary and artistic work, designs, symbols, name, and images used in commerce. So let's say if I were to give you a very simple sentence from today's class, it would be: intellectual property law is the law of protecting commercially or socially valuable creations, expressions, identifiers, and information generated through human intellect. But there is a important qualification. IP law is not something about, is not, monopoly to someone. And this is exactly where the subject becomes very interesting. The law is constantly trying to balance two competing interests. One side, we have the creator, the inventor, the entrepreneur, or the business owner who says, I have invested my time or into creating this. Why? So we should not just think of intellectual property as simply this belongs to me. I've created it. This now belongs to me. We should actually think about it as the law gives me a particular bundle of rights for a particular purpose, for a particular period, subject to particular limitations. And that distinction is extremely important in intellectual property. So now we're going to, talk and take a dive in the main categories of intellectual property. So let's say if I were to ask you objects and you're going to tell me what category can you think of. Let's say a pen, a Coca-Cola style brand name, or a photograph, or it could be the shape and appearance of a designer chair, or it could be a secret manufacturing formula. And if I ask you which area of IP law protects each of this, by the end of this lecture, I don't know if you're aware of it right now, but I'm sure by the end of this lecture, you can 100% recognize all of it and you can maybe deal with these problems easily. Should we now start? Is everyone with me?
Oh, yes, ma'am.
Okay, so let's now start with patents. So, what does a patent actually protect? What do you think? What does it protect?
Kind of new inventions, new manufacturing process. You can say we can say.
Mm-hmm.
A
Anyone
logo,
else?
a
A
logo, a
logo.
word.
Okay. Anyone else?
Identity of the authentic.
Like
Right.
word, it should be word mark or something like
Right. So coming back to the fact that I asked what patents actually protect, and I think Vicky was the one who gave a correct answer. If we ever happen to meet Vicky, I'm going to give you a chocolate. So
For sure, ma'am.
patent,
Thank you.
sorry.
Thank you, ma'am.
Okay, okay. So, a patent actually protects an invention. In simple terms, let me put it very simply to you. A patent will, gives the patentee an exclusive legal right in relation to the invention for a limited period. In India, the principal legislation is the Patents Act. The Act contains the substantive and procedural framework governing patents, including patentable inventions, application, examination, opposition, grants, rights of patentees, compulsory licensing, revocation, and infringement. Now, now what do you think would exactly qualify as an invention? What do you guys think?
Anything new and useful to the society.
New and useful to the society, right?
Anything which is very much unique.
Very much unique. Now, this is a very broad description to give for a patent.
Maybe
That's something.
Or maybe a new process or new product we can say, ma'am, or like something which is
Yes.
capable of capable of human application, industrial application.
Right. So, what basic patentability requirement that you will repeatedly encounter are novelty, inventive step, and industrial application. In other words, the invention must be new, not something that everyone knows. It must not be an obvious development of what is, already known. Let's say everyone knows that, if you think about this situation X, then Y is the outcome. If you bring something like this to the registry, they will, disregard it. So it has to be something new, which in which there is an which is not an obvious development of what is already known to the public at large, and it must be capable of industrial application. But again, we live in India, and there is an additional layer which is extremely important. We do not simply ask whether something is new and inventive. We also ask whether the subject matter is excluded from patentability under the Patents Act. Section 3 of the Patent Act contains a very long list that are not inventions within the meaning of this act. And section 4 deals with the inventions relating to atomic energy. This is where Indian patent law becomes particularly interesting. Let's take a classic example of section 3 subclause D. It is designed to prevent patenting a certain new form of known substances unless they demonstrate the enhanced efficacy required by the statutory provisions. This became internationally significant in the very famous case of Novartis AG versus Union of India. So, what happened in this case? This case concerned a anti-cancer drug of Glevic, or there's a very technical chemical word for it, which I'm sure you won't remember even if I mention. So let's call it the term drug Glevic. So what happened in this was that the Supreme Court's decision in 2013 is very, very important for the Indian patent cases because it demonstrated the way in which Indian patent law attempts to balance pharmaceutical innovation with concerns surrounding evergreening and access to medicines. The Supreme Court database record shows this decision as one of the most significant decisions. So when you study patents, do not only think about, inventions and monopolies. Think about these policy questions. How do you encourage pharmaceutical innovation without allowing patent protection to be repeatedly extended over minor modifications of an existing product? So what basically happens is, let's say you a lot of times these pharmaceutical companies, because obviously they're selling these new inventive patentable drugs at a certain price, and when the duration expires, they have to tell the public about, or bring this information to public domain, which again for them in terms of monetary benefit is not very nice. So what these drugs do is that they'll minutely maybe change something and bring it to the patent registry that this is now a new invention that we have done. So Supreme Court was very strict in this, and it especially in terms to pharmaceutical innovations, that you cannot just bring a very minor addition and be like, oh, this is now we have protection for next 10 years as well. That is not something that Indian law stands for. Now, moving on to the very important part, that a patent is not permanent in general. Because of this, why these pharmaceutical companies act the way they do. The term of an Indian patent is 20 years from the filing date, subject to the statutory framework if there's any change modifications as per the time period. And this is important because the patent system is fundamentally a bargain. The inventor gets exclusivity for a limited period. Society eventually gets the invention in the public domain. So, one thing that I would want you to remember from patent law is a bargain between disclosure and exclusivity. I hope everyone's with me.
Oh yes, ma'am.
So let's now move on to copyright law. Anyone who wants to maybe, tell me what do they understand by copyright law?
I mean, common parlance, we had always heard about that some kind of YouTube channel has put a copyright strike on someone else. You can say artistic work of
Mm-hmm.
artistic
Yes,
work,
ma'am. Creative work such as
creative work, songs.
books, photographs, software, and etc.
Right. Perfect. All of you are completely right. Let's, you know, let's suppose I write a book, or maybe I compose a song. I make a film. I take a picture. I create an illustration, or I could write a computer program. All of these things come under copyright law. But I actually have a very good question right now. Let's assume I have been thinking about this song. I've been thinking about this song, and I have the entire lyrics prepared for this song, but it is all in my brain. Can I still get a copyright for it?
No,
No. And
No,
why is that?
because it is an idea which is not yet expressed.
not yet published or expressed exactly.
That is very, very important. So one of the biggest facet of copyright law is that it does not protect the mere idea. If you have an idea, till the time it is not expressed, till the time it is not fixated, it will not be protected, right? So in India, copyright is primarily governed by Copyright Act 1957. The act deals with copyright ownership, the rights of copyright owners, duration, licensing, copyright societies, performers' right, infringement, and civil and criminal remedies. One of the most important concept is what we've just discussed, that the copyright protects expression and not such ideas. Just to elaborate a little bit on it so that everyone's with me, let's say I want to maybe write a story of a young lawyer who discovers corruption inside a powerful corporation. This mere idea that I want to write this story, or I'm, let's say, thinking of writing a story, something that is very fascinating. This mere idea, I can generally not monopolize it through copyright. But if I actually write the story with my particular characters, dialogue, sequence, narrative, structure, expression, and particular expression, this mere expression of my ideas is what copyright protects. The distinction between idea and expression is very fundamental. Another very interesting characteristic of copyright is that the protection generally arises automatically when the qualifying work is created. Registration is not what creates copyright. This is very different from the general what would you say? This is very different from a trademark or patent, because, like, in that, you immediately need registration. In copyright, you don't need registration immediately. So if you take a picture today, you do not first have to get run to the copyright office and the registrar that, oh, I have this picture, I need a copyright registration for it. The copyright law gives owner a bundle of rights depending on the work and the statutory provision. These include rights relating to reproduction, communication to the public, adaptation, translation, and other forms of exploitation. But copyright is again not, absolute. No right is absolute. So Section 52 of the Copyright Act also provides for acts which do not constitute infringement in specified circumstances. This is where concepts such as fair dealing become extremely important. Let's say a university student photocopies a limited portion of a work for a genuine educational purpose. Or what do you think? Is this allowed in copyright, or are you infringing copyright?
Oh, yes, allowed.
And why is that?
It is not with the purpose of, let's say, robbing the artist of their rightful claim. It is more so for a educational purpose.
Right. Anyone else?
Ma'am, it is not for commercial purpose. It is just for educational purpose, and because of that, it is allowed.
Right. So this is what we understand, right? That if what fair dealing is, that till the time it's for educational purposes, or let's say a journalist uses portion of a work for the purpose of reporting, for telling people, or let's say there are movies and there are movie critics. So if someone's criticizing a movie, or while doing that, while criticizing, they're using the plot of the movie, all these things are recognized by law. The law does not simply says that the copyright owner owns it, that therefore nobody else can touch it. This is not what it does. There are certain exceptions, and these are all there under section 52. The What actually copyright contains is internal limitation designed to preserve other social interest. And this gives us one fundamental lesson. IP rights can be exclusive, but they're not absolute. So now I have a very interesting question about copyright. Can let's see if you guys get an answer. Does everyone understand what snow is, or like ice or snow? Let's assume I happen to use that snow, very interesting snowman. Created that snowman, it is there. Do you think that is protected? Do you think that I can apply for a copyright for a snowman?
No, ma'am. I think so. No, it get disappear after. How can you apply for any copyright?
Anyone else? Any other opinion?
Ma'am, copyright is literary artistic, which is there, but this is already in the public domain. It is not, which is very uh, new to the society or people. So
No, but we are talking about copyright law. It doesn't matter if it's new. I'm just saying that, let's assume I saw snow and I wanted to make a snowman, and it is a very, it is, it is, I have, I have expressed it. So now that snowman, I am just asking, do you think I can protect that snowman? Or let's say, is everyone aware of ice skating rings? When there is like a people skate on it, a massive chunk of ice, and I happen to draw a design on it. Do you think this is protected?
I personally think the first instance that you cited should not be protected, by the second should be protected, because the first doesn't seem like unique expression to me.
Okay. Anyone else? Okay. So, do you remember I used this word fixation when I was telling about idea and expression? So, various jurisdictions have a very, take on the copyright law actually has this word fixation. I'm not 100% sure on it. I think that the has this word fixation on it, and this actually falls in Europe. This is actually a case in Europe that someone created a snowman, a very unique looking snowman, expressed it. It was expressed, right? It was present. Let's say 30 minutes, but that idea was fixated. So it's not for a long duration. This could be, let's say, it could be with a picture. I click a picture, and then maybe I have that in a physical form. That idea is expressed, and at least in Europe, still a gray area about which the court has not really taken a very strong stand. Seen world how long the fixation is. Till the time an idea was expressed, it was fixated. There is copyright that exists in this. Is everyone with me? Does it make sense? Okay. So we're now going to move ahead to trademark. This is something which I really enjoy. This is the most, fun part of IP for me. And this is very close in the word Nike or the logo of you will immediately associate this to a particular source. Or let's say something as simple as food delivery. I'm sure everyone only thought of Zomato. So this, this, this is the principal Indian legislation that governs this is the Trademarks Act 1999 and Section 28 by registration. Section 29 deals with infringement of registered trademark, important limitations on what what is the role of
A very unique image. For example, Zomato. Like they have a very unique image of Zomato.
anyone else. I'm looking for a particular word for something that is very relevant in trademark.
Ma'am,
So
brand identity.
No.
I personally believe it protects the authenticity of any product or service. So we know that.
100%. All of you are right. I'm not denying anyone's claims. I'm just saying that when you think of trademark and when you think of it as a source of, indicating where these goods are from, what does it do? What is the purpose of a trademark?
Identify the correct brand.
I'm
Ma'am,
sorry,
to
Vicky,
stop
your
for
voice
getting
is cracking.
It's kind of distinguishing good from the another good.
Guys,
From the
one by
another
one.
another
Shh. One by one. Raise your hands.
one, so that
No, no, wait. One by one. Raise your hands. Vicky, could you guys? Can everyone please mute their mic? I'll give everyone a chance. Rishank, what do you feel?
Yes, ma'am. I think that it protects the brand's authentic logo, which helps people
This is not
identify.
my. I'm sorry to interrupt. This is not my question. I know what trademark does. I am saying I'm looking for a particular word that is the basic function of a trademark and is very relevant. Yes,
To
Nikhil.
protect the symbol.
ma'am, to stop for getting misused.
No, Nikhil. Next, what do you feel, Divya?
Is it about logo or a particular brand that your word looking
No,
for?
no. Anuj?
Ma'am, to avoid the confusion in the consumer's mind.
No.
ma'am, trade secrets.
No. Is there
distinguishing the
anyone
one
else
good,
who would like to
Goodwill,
take a
goodwill,
chance? No,
goodwill.
distinguishing one goods
no,
from the another one, we can say, in terms
no.
of protection of their rights.
Is there anything else anyone who wants to say, or should I go ahead and give an answer?
Some quality assurance.
No,
A special symbol, a special word, a
no.
special design.
Guys,
Origin of
no.
good.
Okay, no, no. Let's get back. So, what what trademark actually does, but the basic function of trademark is to create distinctiveness. this word distinctiveness is very, very important. So you'll keep every time you think about trademark, think about it, when you register a trademark, or when you're going ahead to commercially, when you'll come into practice, that is the time when distinctiveness, acquired distinctiveness, these things play significant importance. So let's say a client comes to you and has been in business for years. Guys, I'm very sorry, I have to take a call. Give me 2 minutes. You will tell the registrar that my client has been in this business for so many years, and there's this acquired distinctiveness that they have achieved. So that is one of the main reasons why they should get a mark. Or let's say, let's assume if Zomato were to file a trademark now, if there was no trademark under the name of Zomato, do you think that the court should give them due importance, because of the fact that everyone thinks of Zomato, like the minute they think about food delivery, they think about Zomato? Do you guys agree to that? So, what a trademark helps is the consumer to, as all of you said, identify the commercial source of goods and service. And this is how it is different from patent law. Patent law is something that protects the invention. Copyright protects the expression. What trademark law does is it basically protects, or helps the business owners to keep their brand, their goodwill, their reputation distinct from others, or from other competitors. A trademark primarily protects a sign that distinguishes one trader's good or service from those of another. This could be a word mark, this could be a logo, it could be a combination of elements. It can also be, depending again on the legal system and circumstances, non-traditional form of marks. But there is a very important question that again I want to ask. Can I trademark absolutely any word? Let's say I want to, let's just assume any random word. Can I trademark it?
I think yes, as long as it's distinctive and not prohibited by law.
Yes, that is actually a very correct answer. So, because the law does not want businesses to monopolize ordinary descriptive language unnecessarily, that is why distinctiveness is very important. The Trademark Act contains grounds relating to marks that are not distinctive and marks that are descriptive or otherwise unsuitable for registration, as well as grounds concerning conflicts with earlier marks. So this gives us a distinction between absolute grounds and relative grounds. So there are the section 9 and 11. There are absolute grounds of refusal when you can, on moral grounds or something that is against the nation, and there are relative grounds which are in comparison to existing marks. Um, so section 11 deals with those relative grounds where, including if there is a conflict with an earlier trademark, you can get a notice of opposition from the other business owners who already own a mark that is, similar to your mark. So let me maybe give you an example. Suppose I want to launch a company selling apples, and I want to register the mark Red Apple for actual apples. Would you expect that to be a strong trademark?
No,
And why is that?
because if anyone else is selling Apple, then
Mm-hmm.
there is not, you can't register Apple on Apple. You can do it in other terms, like in smartphone company, you can do it.
And why? What would be the reasoning for it?
मैम अगर और कोई सेल कर रहा है एप्पल, तो वो एप्पल्स
Mm.
बोलेगा रेड एप्पल्स, तो वो कैसे, ये मतलब एक हित में नहीं हुआ ना उसके।
So you are very close. I think the correct thing would be that the words are closely connected with goods, right? Your mark cannot be descriptive of what you're selling, because there are multiple people who are doing the same business, right? You will not, there's not only one single person who's doing a particular business. So when there are multiple people, and if one person creates a monopoly over that word that describes the good or describes the quality of the good, that is unfair. So, but if I use a highly distinctive invented word for, let's say, for my legal consultancy, or let's say I'm associated with Sharma Camp Chambers. So this is a very distinctive, word for a legal chamber. So there must be this is a very strong thing to do from a trademark perspective. So every time when clients come to us and they want to register their mark, we always tell them that it should not be descriptive. You should always think of something unique for your business, which is very, which is not explaining the quality of your business. So these are very basic things that you should always remember when you think of trademark. One of the first practical lesson, for any business lawyer is this, that do not choose a brand. Like, you think of a brand, you've got an MSME, you've got a GST certificate, you've incorporated the company, and then you think about the IP protection. This is something that no one should do. IP strategy should begin before the brand is launched. There's also something known as so when when you talk about this, is all of this is a very practical bit of trademark. So when a client comes to you and they want to get a filing done, there is also this niche classification system which is worldwide accepted, and which is where where the goods and services are categorized. So you find the relevant class, and then you conduct a search report for the name that your client has approached you with, and then you prepare a search report for them. You provide them with a search report, and then you tell them if you think there is a risk, high risk, low risk, to go ahead with this. uh, is there anyone who wants to tell me what is the difference between a trademark objection and a trademark opposition? There's anyone, guys? A trademark objection and trademark opposition. There are no right or wrong answers. Feel free to have a conversation.
Trademark.
Poonam, I cannot hear you. I think Poonam's trying to say something.
Hello, can you hear me, ma'am?
Yes, yes, yes. I can hear you now. Please tell us.
Objection is that you cannot release that idea or picture or logo, and opposition is if the same person is displaying the same product or logo or words that is came from the other side.
No, Poonam, that is not what objection or opposition actually means. Uh, anyone else?
Ma'am,
Yes, yes, Anuj.
ma'am, objection is the competitor is objectioning you after registering the trademark, and ma'am, the like opposition is actually that ma'am, competitor is objectioning, and the objection is the government personnel is objectioning, or the reviewer who are the inspecting the trademark or logos of your company to be registered before registering it.
Yes, exactly, Anuj. So every time you think about objection and opposition, do not confuse it. Do not use the word objection with opposition, and do not use the word opposition with an objection. What you just did right now, this will just confuse you. So think about objection when you file the trademark, and let's say the registry thinks, oh, this is not in accordance to Section 9 or Section 11. So it will send you an examination report saying that, oh, we cannot proceed with this because it is, let's say, very descriptive, or is not distinctive, or is this or some reason. So that is an objection. And what we understand by an opposition is when some other party opposes your mark, that a similar mark is already existing in the market. That is what is understood by opposition. Is that clear to everyone? Is everyone with me?
Ma'am,
Okay. Sorry. Yes, yes, Palak, please tell me.
ma'am, opposition is mostly for third party only. No?
Yes, any person who owns a mark and is thinking that this mark, which the applicant has, applied, is, contradictory. That is when opposition comes in play. Objection comes from the registry itself, right?
Means if they are not fulfilling the eligibility criteria, then it's objection. And when
No, 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 no. There is no eligibility criteria. It is just very simple that when a trademark registry objects your mark, that it is not, there are certain objections that you need to clear. That is an objection, and opposition is something that comes from a party who owns a mark.
Okay, ma'am, got it.
Okay, perfect. So now coming back to that, how a brand should not like choose a mark and then later on think about IP protection. IP strategy should begin before the brand is launched. And when we talk about, let's say, trademark infringement, one of the classic cases would be Cadila Healthcare versus Cadila Pharmaceuticals. The Supreme Court emphasized that deceptive similarity must be assessed holistically, considering factors such as nature of the mark, class of the purchaser, and circumstances of the trademark. And this principle has been a very fundamental principle in all the trademark cases that you will read. That when you think about what does deceptive, anyone who would like to tell me what do you understand by deceptive similarity?
Like,
Something
you
which
know,
can trick the general eye into believing that the product is one from the trademark known already.
Such
Um,
similarity which might create confusion among the customers.
exactly.
mislead them.
Exactly. So deceptive similarity means that your mark is, let's say, you know, somehow similar to an existing mark. But when you think about this deceptive similarity, it must be considered as whole. And there are certain factors that you should, address. First, what is the nature of the marks? Is it a word mark, device mark? Is it contradicting? Are these the same kind of marks? What is the class of purchasers who are for whom these products are or these marks are for? What is the circumstance of the trade? There are certain, let's say, medicines. When it's something like medicines and a brand is seeking for a mark, a consumer is very aware when they're buying medicine. And at the same time, let's think of an FMCG good. Consumers have an average memory when you're considering an FMCG good, so they're not very aware. So that is how the court wants you to analyze these things holistically when considering a trademark. The ultimate thing that matters in this is that what an average consumer is thinking, right? Also, my next question, I think it's time for a next question. What is well-known trademark explained in the Trademark Act? Anyone? Anuj, I see you. You've raised hand.
Which is being used for a long time, we can say, or for a well-known period.
Okay, yes. Anyone else?
Yes, ma'am. A well-known trademark is a trademark that has become so well recognized by a substantial segment of the relevant public that is used of the trademark in relation to other goods or services may indicate a connection with the owner of the original trademark.
Right. All of you are perfectly right that a well-known trademark is, something that is very what do we say? Something that is recognized by a lot of public. My next question would be, and think about it before you answer. If let's say there's a well-known trademark and that company has that, let's say Amul, it's a well-known trademark. What is the benefit of being a well-known trademark? Yes, Anuj.
Could you please repeat the question? My network is not good here.
No worries. I just said that let's say there is a well-known trademark. Now, what is the benefit of being a well-known trademark? What is the benefit of to that business owner?
It will create
Ma'am,
goodwill and a different image. Even if the consumer don't remember the brand name, they can still distinguish between the actual good they want and the different fake one.
No, but what protection are they getting from the law is what I'm trying to ask.
Some protection of goodwill.
And
I
how are they getting this protection?
And their goods are being distinguished from the other such goods, similar
But
goods.
how is this happening? I am, guys, what I'm trying to ask is, let's say Amul is a well-known trademark. What benefit is Amul getting it
ma'am, no
from
one,
the
no
law?
one can, no other milk company can take his its brand name Amul. That is the
But
no one
no
can
other
copy.
company can take Sachi if there's, let's say, a small brand that is, registered for selling milk. No other company can take that name. You'll get an objection and then an opposition.
Ma'am, cross
Uh,
protection, cross
ma'am,
class protection. It's the class of the
who
brand.
said that? Who's given me that answer? Is that Anuj?
Yes, ma'am.
Anuj, you'll get a chocolate from me if we ever happen to meet. Yes. What makes a well-known trademark different is that they get protection in all the classes. They have this superpower of, and if a registry will, see you filing something like Amul, or let's say or something that's deceptively similar to Amul, you will immediately get an objection. So that is what the superpower is, that you get a cross-border across all classes, you will get a protection.
Ma'am, can I
So
just interfere? Just a minute.
yes, 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 please.
As you said, Amul that you are talking about is a dairy. Amul, उसकी बात कर रहे हो ना आप?
Yes, yes.
तो अमूल मैम ये इनरवेयर्स भी तो आते हैं, अमूल माचो एंड अमूल, तो वो तो यूज कर रहे हैं फिर।
I'm not very sure either. They would have like a similar time of registration, or if when Amul Macho, are you sure that it's not a subsidiary of that?
नो इट्स नॉट।
So the only reason behind this is there's a very similar example of, I don't know if you guys are aware of it. There is one brand that sells rice by the name of India Gate Basmati,
यस।
and there is a similar brand, the same branding, same logo, India Gate, who only deals with maida, atta, and these things. They do not enter rice. And that is because the court had very well defined. So it could be that both these marks are, being used for a very long time, and people have started, you know. So when you think about macho, you immediately link a mole to it, right?
यस एग्जैक्टली।
So that is when the either there is an extremely old prior use where you cannot defend the goodwill of both brands that they've built simultaneously. But what is defined over here is that they will never penetrate into each other's class. That is very distinct, very clearly mentioned.
ओके नो
I
प्रॉब्लम।
hope that helps your question.
या नो प्रॉब्लम।
Okay. So, guys, let's now move on to. I think we are also running a little short on time. I'll quickly move ahead with that trademark law. What ultimately trademark law asks is there a sufficient likelihood of confusion, deception, or association depending on the applicable legal test? And that is why trademarks are fundamentally about brand identity and consumer perception. Now we are going to move on to. I still have, I think, two or three bit to cover. Sakshi, is it okay if we extend the time maybe by like 5 to 7 minutes? I'll wrap it up
Yes,
quickly.
yes, yes, ma'am. No issues.
Okay. So now coming to industrial design. Now imagine that a company creates a chair. The technical mechanism of the chair may not be, let's say innovative, but the chair has a very distinctive visual appearance. Or imagine a bottle has a with a very distinctive shape, or let's say a textile with particular ornament, very distinctive pattern. Which law might protect the visual appearance? In India, this is governed primarily by Design Act. The statutory concept of design focuses on features such as shape, configuration, pattern, ornament, or composition of lines or colors applied to an article and judged solely by the eye. The key point is that design law is concerned with the aesthetic or visual appearance of the article rather than the technical function. It has nothing to do with the technical function. And a lot of students do get confused with patterns and design. So let me try and maybe make the distinction very simple. Guys, if everyone could please mute their mics. So let me try and make this distinction simple for you. If I invent, let's say, a uh, technical mechanism inside a machine, that maybe, that technical inventive step, which is, for which is new, that is what we're talking about, patent protection. And if I create distinctive visual appearance for the machine, then we're talking about design protection. So sometimes, depending on the facts, more than one IP may be potentially relevant. And this is a very recurring theme in IP law. One commercial product can contain multiple layers of intellectual property. Maybe let's think about a smartphone. The technology may involve patents, the software may involve copyright, the brand name may involve trademark, and the external appearance may potentially be about design protection. The company may also have a confidential information and trade secrets of how they're doing this, how they're creating it. So the product is one thing commercially, but legally it can be a bundle of IP rights. Uh, Moving on, we move to trade secrets and confidential informations. I'm going to keep all of these things very brief because I think I've covered a lot of significant IP. Now let's maybe think about something different. Let's assume I happen to run a restaurant and I have a very secret recipe which is very famous and everyone wants to have that particular taste. Or let's say I run a manufacturing company and I have a confidential manufacturing process. Or let's say I have a consumer list, which is very confidential. Can I patent this information? Not necessarily, because this is not inventive, this is not applicable for industrial application. In fact, patenting it may be very contrary to what kind of protection I want. This is where trade secrets become very important. WIPO actually describes trade secrets as commercially valuable confidential information that is kept secret and protected through reasonable steps. The fundamental difference is therefore patent protection is based on disclosure. Trade secrets protection is based on complete secrecy. And India does not currently have a very comprehensive standalone statute equivalent to a dedicated trade secret act governing the entire field. Protection may instead arise through contractual obligations, confidentiality, agreements, equitable principles, and action of breach of confidence, along with other applicable legal mechanism. So when an employee leaves the company, before leaving the company, the employer downloads the company's entire confidential customer database and gives it to the competitor. This raises a very different legal problem from someone copying a registered trademark. The legal issue may involve breach of confidentiality, contractual obligations, and misuse of confidential information. And then again, the strategy will completely depend on the nature of the information. Now, moving on to our last bit, that is the geographical indication and specialized right. So there are also several specialized form of IP protection. One of the important category in India is GI. So think about Darjeeling tea, a Banarsi sari, or let's say Kashmiri kawa or Kashmiri, kesar. These, the basic idea behind a geographical indication is that the product has a particular geographical connection, and that is its quality, reputation, or characteristics are essentially attributable to a geographical area or a geographical origin. WIPO describes GI as a sign identifying goods originating in a particular geographical area where a given quality, reputation, or other characteristics is essentially attributable to that origin. India has the Geographical Indication of Goods Registration and Protection Act 1999. This act is a part of India's principal IP legislative framework alongside Patent, Copyright, Trademark, and Design Act. We have also specialized regimes concerning areas such as plant varieties, semiconductor, integrated circuit layout designs. The important takeaway is not that you need to memorize every IP right today. That is not what I want. What I just want you to understand that when you think about IP, do not, confuse the basics and do not think about it as one single right. It is the collection of a different variety of legal regimes that is designed for very different kind of intangible assets. And I hope that helps you with everything that I'm trying to, that, what IP is about. And this was very basic, information about what IP is. Maybe maybe I would like to conclude it by giving you a international architecture of IP. That why do we need international IP law? Because IP is not something, since it's intangible, and we live in such modern times with the emergence of AI technology and so much more out there. IP does not respect national borders. Suppose I develop an invention in India. I may want to commercialize it in US, Europe, Japan, Singapore. Or let's take an example that I happen to create a film in India. It may be streamed globally, and within that could be within hours. And suppose I develop a brand in India. I may want to sell the product outside. So if IP rights are territorial, how do we, deal with international commerce? This is where international IP treaties become very important. And at the center of all of this is the World Intellectual Property Organization. This administers numerous international treaties system dealing with different forms of IP. Some of the most important would be the Paris Convention, the Berne Convention, TRIPS Agreement, or the Madrid system. So I'm not going to go in the detail of it. I think we're really running short on time. Uh, there is a lot to IP. I hope I've been able to help you with some parts of it. And I think that's it from my side. Sakshi?
Thank you so much,
Thank you,
ma'am,
ma'am.
for such an enlightening and engaging presentation. I'm certain our participants now have a clear perspective on the scope and importance of intellectual property law. Participants, if you have any question, you can ask.
Ma'am, can I ask question?
Yes, yes. Please feel free.
I have read somewhere कि ऊपर एक आर रजिस्टर्ड भी होता है, उसमें और ट्रेडमार्क में क्या फर्क होता है मैम? सर्कल में रजिस्टर्ड आर मार्क होता है, उसमें और ट्रेडमार्क में क्या फर्क होता है मैम?
Hello?
Yeah, ma'am. Now you are audible.
So when you write a TM, that
Yes.
trademark is claimed but not necessarily registered. That is what that signifies. And a R, that is a registered trademark. So let's say you talk about a well-known trademark, they will usually have a R written next to them because that's a registered trademark. I hope that helps.
Okay, okay, no
But
problem.
one query related to registration and non-registration. Can I ask me? Is it okay if the trademark is belongs to TM only, or we have to register it?
I did not understand your question, ma'am. If you could please repeat.
मैम अगर TM लिखा है तो is that enough और register करना ही है?
That completely depends on the business owner with what perspective are they thinking of a brand, what scalability they're thinking of. That is a completely personal choice. I mean, if someone wants to register a trademark, they should go about it in the proper way. There has to be a proper filing. Hopefully, there are no objections and oppositions, and then you have to, get a final certificate from the registry.
Okay, and what will be the advantages and disadvantages when we register and non-registration of trademark?
For trademark registration, I would say that if let's assume there's a brand X and someone's just started their business, and with this brand X they want to move ahead, and by the grace of God and their hard work, this brand blows up and it becomes a very let's say it becomes a unicorn. Firstly, you will not get funding if your IPs are not protected, and second, there'll be multiple significant copies of your brand if you're not protecting your IP in today's generation, especially when we live in in times when there is so much of technology around us. So there are only advantages of protecting your trademark. I can't think of any disadvantage of protecting your trademark. If for someone, let's say, maybe cost could be a thing.
Okay.
This, uh, if that's it for today,
Uh,
can
I
I?
just had a query. Hello. Yeah, so I was wondering about industrial design and trade secrets. Let's say, in the absence of any legislation, could they not be protected also as a matter of copyright?
No, ma'am. So that is not how it works. That is not how, again, you cannot, as I said, when you think of IP, I don't want you to think of it as one single law. There are a lot of law regimes that work under it. A trade secret, let's say, now in a trade secret, if you think of copyright, there has to be expression. If you express your trade secret, how is it a secret anymore? Similarly, in design there has to be a technical element. So that and copyright has artistic, pictures, music. It is a very literary. Other kind. These are two separate. These are like completely separate fields under IP. You should never think of IP as something that is one single law. There are various facets to it, and you should always as a lawyer, when a client comes to you, you should always think about it in layers rather than approaching it as one single IP right that I can maybe create for the lawyer. What I've in like even in today's workshop, I've tried to keep it as practically. I hope this helps your question.
Uh, Definitely. The reason I asked that was because I also visualize trade secrets as a sort of expression within the company. So when looked as that, I thought maybe it could be, but I can also see the perception that if you see it as an idea, or copyright would not apply. I think that's very helpful.
As we conclude, I would like to express our sincere appreciation to Advocate Vedika Mittal ma'am for sharing your knowledge and practical insights with us today. Your guidance has inspired our participants to explore intellectual property law with greater confidence and curiosity. Before leaving, we request everyone to kindly complete the feedback form that will be shared in the chat box. Your input helps us design more impactful session in the future. And now let's capture the moment with a virtual photograph. I invite everyone to switch on their cameras for a quick snapshot.
Thank you, Shalu. Thank you so much for your kind words, and I hope I could have I would be if I would have more time, we could maybe share some more practical insights. But I hope everyone has now some basic understanding of IP law. Thank you so much for your time, and I hopefully I've not bored you all to death. Have a lovely evening.
Thank you, ma'am. Thank you all for being part of today's session. We look forward